Thank you again. I just introduced myself a little bit earlier. My name is Luca Escoffier. I run the Technology Transfer Helpdesk, the Japan Center. Thanks for being with us. It's really good to see old faces, but also a lot of new faces. So I'm very happy to welcome you here today. And I hope that you enjoy so far the discussion. We will have some questions now during the panel. So I will invite the speakers to gently come to the podium and take a seat. Probably here, so that we can have. Thank you. Yes, and we can have a short discussion, and then for those that are brave enough to endure for another 40 minutes, we can have some time for the networking reception. We can stay together until 7 p.m. today. So we're not exactly in the order of presentations, but so let me go starting from the closest of the speakers to me. Thanks for the presentation. Was really clear. I guess I do have some questions in my mind, starting with we talk about just touch upon some of the features of the UPS. So what do you think are the most attractive for applicants? We talk about one register, one single registration, and the possibility one day when the court will be established to mediate just in front of one court with covering different jurisdictions. What do you think for a company in Europe or even outside of Europe, if there are any differences, would be appealed by?
Yes, thank you for that. Interesting question. Can you hear me? It should be the case. Very good. Now, the point of departure for this whole thing is that we have a very effective prosecution system for patents in Europe, which has been built up over the years in the regime of the And the major feature that will impact the European scene here is obviously the unitary patent court that we'll put on top of the prosecution system that we have over there. So the way I look on it, it will obviously be the new court that will be the one single thing that will benefit companies the most. Will there be differences in how this will favor companies from inside or outside Europe? I don't think so. They will operate under the same regime, will be the same rules of procedure for the courts, it will be the same panel to take the cases. And I believe that the new system will provide better access to justice for foreign companies as well as SMEs in Europe, where the situation unfortunately today is that it is very difficult to defend a patent right if you are a small company that is on the rising patent as we see with quite many of them. So I can take my own country as an example. We have some very large companies in Denmark, but the vast majority of companies in Denmark are in the SME group. And I think that they count for close to 70% of all labor in the industry. So it is a hugely important segment for the economy, for the welfare of the country, etc. So we are in Denmark very pleased with this decision, and are looking forward to see it in realized.
Thank you. Clear again. Moving on with the next speaker, you just touched very briefly upon the doctrine of equivalent in one of your slides. I don't know if you have any, you can provide us with some updates in terms of maybe differences, if any, in the application of the doctrine. And first of all, maybe not everyone in the audience is aware of the existence and knows what it is, so maybe if you can provide a short information. Thank you.
Well,
can you? Yeah. Well, first of all, what is the doctrine of equivalence? The doctrine of equivalence is a concept in law in which things, potentially infringing products, which are not covered word by word by the claims of granted patent can still be considered infringing if they would, let's say, applying some certain legal rules, be considered as still falling on those, because there's something like a halo, yeah, around the patent, a halo, like a bit of shine around the patent. Even though the words are extremely clear, there is a bit of shine, sometimes a bit more light in one area, complete darkness in the other. But if you would try to avoid it and you're still doing that, then a court might find you and still infringing even you do not read this word by word. Going back to your question, yes. That is, this problem, you see, exactly that. You see that the courts, the national courts struggle also with these concepts. On one hand, you have there is a, let's say, German decision on that one, which is calling 3 criteria, and then finally a 4th one which has to be applied. These 3 criteria were followed relatively close by the Swiss, not EU, but EPC naturally. But yeah, a little slip of tongue is a bit different. So they followed quite, but in the end of the day, no one could resist to set his own mark, which is a 2016 decision. And then there was, relatively recently, a decision by the British court, Architecture against Eli Lilly. In the beginning, the whole thing sounded like, okay, we believe you. So they followed let's say, the German example, and the points 1 already deviated in point 2, and the 3rd one was giving it a completely other tongue, slip of tongue. What was it? In this case, it is more the question, would you believe, when you write it, that the limitation was intended by the patent owner? I know this is very much allowed, legal grammatics around, but this gives a clear indication that the British want to have a more, let's say, individual touch to the whole thing, opposed to the clear rules set out. So coming back to that, yes, so they tend to go together, but their feet are going from, so the upper bodies move together, while they try to steal their own feet somewhere to the left and the right. Very much the European way of dealing with that.
Thank you. Sakai-san, next question for you. Japanese is more than rusty, but I kind of probably heard that you were mentioning a certain Mr. X in your presentation. Why?
So, sorry, in Japanese. 検察の側でX という方が日本憲法と別に X がいたということで、私の判決を行い申し上げましたけれども、おそらくはそれはわら人形といいますか、背後に別の会社がいらっしゃったんだろうと推測します。やはり向こう出版請求がおっしゃっているのは非常にお金がかかりますというので、単純な興味関心で検討されたわけではもちろんないと思います。ただですね、当時は何度も公出版請求を申し立てることができたわけですけれども、2015年から特例に申し立て制度が日本でも導入されまして、それによりまして公出版請求は利害関係人のみ請求できるということになりましたので、先ほどの事案というのは改正前の事案でしたけれども、改正後の事案であります。改正後は現在ではおそらくああいった形で個人が利害関係なく公出版を訴えることというのは難しくなっているというふうに思いますので、X というのは改正前の事案だったからこそ動くことができたのではないかなというふうに考えております。
Mystery solved. Thank you. Moving on to the privacy issues. what do you think, you touched a little bit upon the concept of AI, how hot AI would be in the world of privacy as well, not only, but how difficult you see in practice will be for data controllers in companies, organizations, when trying to get the consent, manage the consent for the data processing, when there will be AI systems, algorithms. You're a programmer, right? A developer yourself, so you know there might be this risk when the company, the controller, will just say to the AI, just reach this point, just reach this result, and just do it as you think will be fit. How will be there will be some difficulties in getting the consent, since you always have to mention how you're going to process the data, for which purposes.
Yeah, well, yeah, thanks for that one. This is a very, really hot topic right now, like fresh out of the oven.
And maybe, sorry, because maybe the audience doesn't know the difference between data controllers or processors, which is something that is defined in the.
Okay, so from a data controller, so this would be actually the business operator, so who is actually in charge and accountable for this data. So if you have a processor, so for example, an external provider like a cloud service provider, for example, this would be called a processor, so defined by the GDPR. So now regarding to your question, from a developer perspective, so regarding obstacles, then maybe yes, the GDPR might be the biggest obstacle in order to to get or to comply with consent. But the problem with AI is now this is a very, very, very new technology, and there is still not that much experience with AI. So when someone is asking me about AI, I try to, let's say, try to align it with some other technology like common navigation, for example. So the first steps of common navigation, it's there, it does something, nobody knows how it does it, so from the first airplane, and no one is aware of the possible risk yet. And the possible risks and how it starts to work came over the time. And this is now with AI also one thing. If you break it down from technology perspective, if you really break it down to the most high-level simple thing, it would be automated decision making and of course automated profiling. First, an AI requires profiles. And the good thing about the GDPR is profiling is a really red flag, so you do have to comply with a lot of things related to the GDPR. And yes, you can go for consent. You can ask the person for consent. But then I also would like to ask what happens if you consent to buy a car. You're going to consent for a partnership relation something page. And you consent for opening a bank account. And 1 week later, you are a sex offender, you're a car theft, and you're done for tax fraud. Because you don't know, actually, what the logic and everything behind is going to do with your consent, if it's automatically taking your consent into the next decisions. And then we're coming back to the point of data ethics. So, in order now to get consent, the controller and the processor needs safeguards to use this legal basis consent to process data on the artificial intelligence base. And I guess this is at the moment the biggest obstacle. You're implementing the safeguards for consent. How to make sure that your consent, your data is not going to be abused or has negative decision making on your person. when I mentioned data ethics, and this is probably also a part of the developing team, so it's called ethicists. So ethicists should be, or should join the team, develop a logic together with decision makers, sit together and create an auditing trail, for example, so that you at least, and this is a really complicated topic, so at least that you can give the data subject enough information to make a real choice on the consent. Because it needs to be explicit consent, it needs to be freely given consent. And in the past, there were some discussions about some article right of explanation. So this was a really big thing going on. But basically, it was the meaning of Article 15, meaningful information. So the person has the possibility to look behind the logic on a certain level to understand, okay, this is the logic behind the AI, and on this basis, the person can decide. But as I said, the biggest problem now will be to ensure proper or implement proper safeguards, because, as I said, at the end, you don't know.
Speaking of consent, how is there any provision in GDPR in practice talking about how to objectively certify a date, let's say, to have a stamp about the certainty that a consent has been given on a certain moment, on a certain date? Let's say that there is, let's say, someone that is making a visit, someone from an authority, and wants to have evidence of a certain date. Are there any certifications in place at the moment, or someone studying on how to implement this?
A date of consent?
To prove to a third party that actually the consent has been, otherwise someone can ask me if I got the consent, I can just generate an Excel or any kind of file and say, I did it on this day, how can I objectively prove it?
But in case of AI,
in general, yeah.
So how can you prove it? I mean, this is then a privacy by design thing, for example. So if you create simple method, if you have a homepage and you offer a newsletter, for example, and you have to, according to the GDPR, you have to ask for consent. So, and the specialty is that you that the checkbox, for example, is not pre-ticked, so that once again the consent has been freely given by the person, and there needs to be a double check. So you give consent by the checkbox, you receive a mail, and you check again. So this is the next step. So, and based on your design, it makes sense to have a database, for example, who takes this information and stores this in the database. But of course, you can also write it down in an Excel sheet, but then of course it's relevant, more a question about your company's policy and regarding privacy by design, and also a scalable framework for a company.
I have two questions for you. One, I was very intrigued, as probably most of the people in the audience. We talk about the complaint that has been filed in Germany. What is the reason? What is the provision or set of provisions in question?
Yeah, this is not in the public domain, so we can only guess about it. But it is various issues that is related to the way it has been processed through the Bundestag that has been in question. And then there's a couple of additional things to it. But this is based on what you can read on various webs in the public domain. But it's not public information.
Thank you. Totally unrelated, but very important, I guess, for a lot of stakeholders. When I run my activity in the tech transfer helpdesk, sometimes people ask me whether there is a universal registry where they can see technology licensing agreements that are recorded, and of course the answer is yes. Probably you can can find in single individual patent offices. They might have this kind of service available. So do you think that having this unique single register will actually change when the UPC will be enforced? How can really companies or anyway stakeholders benefit from the existence of a single register?
Well, the way you can benefit from it is to find out what has been patented. That is what you can get out of it. The licensing area is very complicated, and a lot of that information is not disseminated to a broader public use. Many companies have these agreements for themselves and does not display them. There is, in certain cases, a need to register that a technology has been licensed, but it varies from country to country. So it will not in itself produce more clarity on the more commercial aspects of licensing, unfortunately.
Okay, good to know. We're talking about AI. I'm very intrigued by the topic. Do you think that there are at the moment, there will be in the near future hurdles that examiners and filers will have to overcome when trying to get a patent on an AI implemented or AI conceived invention? AI conceived, that literally mean an invention that has been created by an AI.
Okay, okay, we start first of all with maybe there is very recently there are guidelines from the I think it's 10 days or something like that. It's just out, and most importantly, you see there that the EPO has heavily targeted the part on guidelines for programs, computer implemented inventions, artificial intelligence, mathematical methods, etc. So if you take a look at that, you see one interesting thing, which I'll back to your question in 1 second. You see that one of the EPOs started from one corner, which I think reality has proved as wrong. This corner was software is nothing that can be patentable. That's where we started. And whereas the US started in the completely other corner and said everything under the sun. And while you see that the US boys, based on Alice's decision, started to be a bit more tough on it, the EPO has started to give more lenience to that, because I think we are simply aware that whether we like it or not, the program and software is ruling the real part of the world, and also of the inventions. So one word, so you can get patents on programs as long as you have an additional technical effect besides just running on a computer. If anyone interested in this area, take a look at this part G of the new guidelines of the EPO. That's quite clear and quite good examples of that. So far I've escaped your question. And now comes invention by an AI. No, sorry. Not a single idea. No, I can't tell you anything about that. I would say it is, as AI are neither legal entities as such, I'm not a legal person, so they can't be inventors. Full stop. Legally, I don't know, any lawyer in the room would I think, prove me right with our inventions. And AI, no problem. Inventions by an AI, I would say you still need somebody pushing the button, and then he might be helped by his AI. So this is what I believe, but hey, I'm out.
Okay, what is the Japanese perspective? Maybe asking Sakai-san.
必ずしも全てこれだけでわけじゃないですけども、日本としてもソフトウェアでAI だったりIoT だったりということを考えて私今年の3月ぐらいの審査基準として東京出願に関する審査基準としてソフトウェアに関するものをアップデートしていたわけです。 そういう形で、基準を明確にすることによって、その AI であったり、そういった関連発明に関する出願を促進しようという意図はおそらくあるのだろうと思います。私のご報告にまた戻ってしまいますけれども、膨大な数の発明が、選択肢がですね、既存の出願、された特許法の中に入っている場合に、今発明が認定できないということを申し上げましたけれども、その判決の文献において、表釈の部分においては、AI がより実験等において用いられることによって、より適正解というものを導きやすくなるということを書かれておりまして、そういった意味で膨大な数というのが、先ほど2000万通り以上で今発明に認定できないということをご説明差し上げましたけれども、もう少し膨大な数、2000万という基準はまた少し変わって、AI の利用によって変わってくる可能性もあるということは、言われている学者はいらっしゃいます。そういう意味で、進歩性が否定されやすくなるという方向かもしれませんけれども、特許出願との関係において、特に有効性との関係において、AI には関係してくる分野かなとは理解しております。
Thank you. I think we have a take also from here, from this side of the room.
Yes, thank you very much. I think this was two very interesting answers we heard here from Dr. Peters and from our Japanese colleagues. So thanks very much for that. It's a little bit frightening subject, this one. So the notion that a machine would be able to produce a result that is patentable without any human interference into it. And obviously we need scholars to look further into this area in order to understand it completely what it is that is going on there. But I would like to back up a little bit and just use a few minutes to get a little bit of an overview of the situation here. Because for the time being we are operating with a lot of new notions, AI, blockchain technology, analytical, big data analyticals, and we can ramble on with all those notions which describe something which have to do with the implementation of digital possibilities of the handling of vast majority of data. And I think that what we've just heard Dr. Peters describe from the recent update of the examination guidelines from the EPO, we can see there that EPO has clearly tried to work with all those notions and get a better grasp on what they are all about. So in that way, the EPO is continuing the road that we in Europe have been on for a quite extensive period of time, whereby we are acknowledging the fact that digital solutions become an integral part of inventions in general. And I think that's the important observation to do here today. Whether we in the future or not will have machines running AI programs that is able to make patents themselves without us being involved, that's a separate question, very interesting, but it's a little bit far-fetched for the time being. So if I should just finish the argument, dear colleagues and friends, I think that we can, in the software area, talk about a conversion whereby we in Europe are getting better and better to understand how the digitalization will influence technologies in general. And I also understand that the similar processes are going on in Japan, and it's very good to hear. Now on the other side of the waters, we have the United States, where we, after Allison, have seen a series of Supreme Court decisions on software business models, patents, not always very consistent and going in the same direction. They have, however, the same ambition of limiting some of the most widely patenting activities that has been going on in the software area in the past. And in that way, the United States and Europe at least is converting towards one another in the way that we look on the subject matter that can be patented. Now bear in mind though that in Europe it is still so that these technologies cannot be included in inventions unless they have a clearly documented technical effect. And we can see now from the update of the guideline, I think that was it, Hajo, that we're talking even about an additional effect. So we're in the process of being better and better in understanding how we practically will handle a thing which is a huge challenge for all of us in the patent area, caused by the new digitalization processes that's going on and being integrated into inventions. Thank you for that opportunity.
Thank you for providing your position. Last question. You mentioned the concept of privacy by design, so I would love you to maybe explain to the audience, because maybe not everyone is familiar to the idea. I was wondering if there will be an intersection, there might be an intersection between this concept and the idea that you have to comply with it, and the drafting of patents, meaning as a company I have to provide evidence that I'm complying with the idea of adhering to the privacy by design. It would be useful to also have as evidence potentially the text of the patent to show that, for example, a new device is actually being conceived by respecting this principle.
Well, yeah, I mean, in general, it would make sense to bring this into a patent as well, because how do you achieve the way of privacy may be also related to a piece of technology, for example, you want to protect as well, so maybe because through a new algorithm for encryption or whatsoever. So this is a matter of perspective now, how we look at it. So yes, it should be included. If you look from a general perspective, you should do this anyway. You should always include your design into the full, or let's say the part into the full design. So privacy is now, from the 25th of May, part of the solution design. And when you create a solution, the part of privacy belongs to it. So yes, it needs to be documented. How could you else, about patent, okay, so is this the answer you were looking for, or?
Yeah, I was thinking about something that can help in having something that is documented with a certain date, it's public, and can help you prove that actually you comply with it. So I don't know if someone else here in the panel has an opinion on this.
I was not into this topic yet, because this was not part of my work right now, but there are some possibilities. I guess it's called code of conduct or something. So companies have the chance by an accredited body to get the certification. So yes, this is possible. There's, for example, one provider, a cloud provider, I guess it's eucoc.cloud something. So this is the accredited board by the EU Commission for cloud providers. And yes, the code of conduct is at least one option to show that you are compliant to the GDPR. One important aspect is, if you go the code of conduct, you are obliged also related to monitoring. And if the body, recognizes that you're not compliant to the GDPR and you have an approved code of conduct, then of course the fines will work on you, let's say. So it's a matter of risk strategy you have to think about.
Yes, please. Yeah.
There's nothing in the law of patents that require you to be able to document that you are fulfilling the requirements of the GDPR or any other regime for regulating data. But it's obvious that the various functions of patent office can be used to document what you've done, when, where, and how, in form of applications, in form of notifications, etc. So there's a whole series of possibilities for that. But it's more an issue related to competition, I would say, and further processes going into court. Now, having an overall view of the whole GDP area, I'm not certain that the patent and the R&D area in itself is where we have the most challenges with GDPR. As I see it, will be primarily in marketing functions and functions where we communicate with customers and service providers, that we have a lot of issues that we have to handle in companies today on the GDPR issue, and there I think that many of us are far behind if you look on the European regulation, and is at risk, as you rightly pointed out earlier on. So there's a lot of work to do. I would say that Japanese companies moving into Europe also need to think quite thoroughly about how they handle that data that will be generated in their interaction with the customers as they implement their business strategy in Europe. And here you have to assure yourself that you are on top of the control of what happens with those data. Now, there's another side of this whole discussion which I think your colleague pointed to before. So one thing is being able to handle primarily data related to individuals. Another side of data is, in fact, that data becomes more and more important as a business asset. So not just about personal information that you cannot leak and use and misuse, but as a business asset. So when we talk to companies today about their intellectual property strategies, we always ask them two questions. Who is in control of your data? And secondly, how do you make sure that you're living up to the regulations as it is? So can you enforce that control? I think there's two fundamental questions that any company had to ask themselves today, and primarily looking on business operations, I would say.
Thank you. Perfectly on time. You mentioned my colleague. I would love Mr. Monaco maybe to say a word if he wants.
Yeah. Okay. Let me.
Yes, please come.
Yes, I feel after spending the entire afternoon with you, I feel obliged to express a real gratitude on the side of the delegation to the participants, to the panelists for the rich and fruitful discussion. We wished for a rich exchange, and I think that we have achieved that. And so, real great things for contributing to another to lay another block in what is a very rich agenda of exchange and cooperation with Japan. Let me take my role as representative of the EU delegation and focus again not so much on the specificity and the technical aspects of the EU regulation, but what is our bilateral agenda in terms of the strategic frameworks that we have developed with Japan, and in particular with the focus on innovation. All what we're doing here is to contribute to mutual understanding, to increase the knowledge for practitioners, for business, for research purposes, and to effectively take a step forward towards a integration, a convergence, or at least an improved communication of our two systems. We have, my deputy ambassador mentioned that this morning we are on the verge of the entry into force of the ratification first and the entry into force of the two main agreements. I mean, I keep receiving every day emails that the agreements have been cleared in the lower house in the Diet. Now we're expecting the vote in the upper house. The same thing is going to happen in Europe. It's a matter of days, weeks. We're very, very close to that. But mind you, apart from the negotiations and the implementation of the agreements that have been concluded, we're already moving with Japan at high level a step forward. We're looking, a month ago in Tokyo there was a high level economic dialogue, which is a forum where our top political leaders, in the case of Japan it was the Ministry of Foreign Affairs, Mr. Kono, and the Ministry of Economy, Trade and Industry, Mr. Seko, sat with their counterparts in the European Union and in the European Commission, and they charted areas of cooperation for the future, exactly strategic areas of cooperation, and innovation was at the heart of these strategies. And if you think of that, the innovation that is declined in technologies and in spheres of cooperation, there are then sectoral. There could be ICT, could be innovation for climate mitigation and adaptation, you name it, it doesn't matter. The essence of the cooperation between the EU and Japan remains innovation. And thanks to the, we as delegation, we assist, we contribute in partnership with the Center for Industrial Cooperation that was behind the organization of this workshop. We are bringing our contribution to facilitate the dialogue, and I think that I can only express my admiration and gratitude, because today we have taken another step on a very technical topic, but that underpins the technological development, the innovation that the cooperation between the EU and Japan is all about. So with that, I think that we can declare the workshop closed. And Luca, can I invite the people to...
Yes, yes. I
Okay,
just wanted
you
to
do it,
thank you for your closing remarks. Once again, the speakers that will be joining us for the reception, and you, of course, for being with us today. Again, it's been really, I think, a very fruitful day. We have enough time to exchange business cards, talk. You have the chance to talk to the speakers, talk among yourself. So please join us, and we can go to the foyer, and everything is ready for us. Thank you again.